Note: the following legal update was featured in the June 2023 edition of IEL's Energy Law Advisor. Over the years, Louisiana courts have been called on to examine the balance of rights between landowners and usufructuaries. Usufructs, similar to life estates in common law jurisdictions, can be granted for limited periods of time rather than one's lifetime. Usufructs burden land placed into possession of naked owners, similar to remainderman in common law. From time to time, issues arise as to the authority of usufructuaries versus landowners, who has the right, and to what extent, they can encumber property. The Louisiana First Circuit recently examined that issue again in the case Pool Doe Properties, LLC v. TLC Properties Incorporated and the Lamar Company, LLC, 22022-1011, La App.1 CIR February 24, 2023 WL 2202-018-2023, which is the basis of this article. A. Overview of relevant property rights in Louisiana law. In Louisiana, a property owner enjoys full rights in property, which includes the usus or the right to enjoy property without altering it, the fructus, which is the right to derive profit from the property possessed, and the abusus, or the right to alienate, consume or destroy property. In contrast, a usufructuary enjoys only the first two limited real rights, and not the right to alienate, consume or destroy property. 1. Types of usufructs in Louisiana. A usufruct in Louisiana arises either by operation of law, legal usufruct, or an inter vivos or mortis causa juridical act, conventional usufruct. See Law Civ. Code Art. 544. Usufructs may be established for a term or under a condition, and are subject to any modification consistent with the nature of usufruct. The rights and obligations of the usufructuary and of the naked owner may be modified by agreement unless modification is prohibited by law or by the grantor in the act establishing the usufruct. If not altered, it will be governed Louisiana law. The most common type of legal usufruct is the surviving spouse usufruct. In Louisiana, under the established law known as matrimonial regimes, property owned by married persons is considered community property. However, married couples can modify or opt out of the community property regime by entering into a matrimonial agreement/prenuptial agreement, which can set forth different rules to govern their property. See Law Civ. Code Art. 2334 etc. When a spouse dies intestate or without a testament, i.e. will, survived by descendants owning community property, by operation of law, the surviving spouse is placed into possession of their undivided one-half interest in the community property, with the decedent's heirs placed into possession of the remaining one-half interest in naked ownership, subject to the usufruct of the surviving spouse. The surviving spouse usufruct will terminate when the surviving spouse dies or remarries, whichever occurs first. See Law Civ. Code Art. 890. The power of a surviving spouse usufructuary to grant a servitude was the subject of Pool, 2023 WL 220-201-8202, discussed below.